I am very upset. My friends have posted my morphed images for making fun of me on social networking site. Everybody is looking at fun with me. I don't want this. This is not as simple. It hurts my self-respect. It is happening in so many places. When I saw on internet, the Internet Crime Report of 2019 released by USA Internet Crime Complaint Center of the Federal Bureau of Investigation has revealed that India stands third in the world among top 20 countries that are victim of internet crime. As per the report, excluding the USA, the UK topped the list with 93,796 victims of internet crime, followed by Canada and then India. These threatening statistics remind me of famous quote of Albert Einstein, "It has become appallingly obvious that our technology has exceeded our humanity." Half a century back, Albert Einstein, one of the most intelligent person of the world, warned us about misuse of technology through destructive mindset. This gives the answer that why government has introduced IT Act 2000. Let us look at it with the inception itself. In 1996, United Nations Commission on International Trade Law adopted the Model Law on Electronic Commerce to bring uniformity in the law in different countries. Further, the General Assembly of United Nations recommended that all countries must consider this model law before making changes in their own laws. India became 12th country to enable cyber law after it passed the IT Act 2000. While the first draft was created by the Ministry of Commerce, Government of India as of E-Commerce Act 1998, it was redrafted as the IT Bill 1999 and passed in May 2000. Impact of the Act on another law. Further, this Act amended the Indian Penal Code 1860, the Indian Evidence Act 1872, the Bankers Books Evidence Act and the RBI Act by allowing them to store books of account in electronic form. The Act has many-folded objectives. These are: first, grant legal recognition to all transactions done via EDI, other electronic means of communication or e-commerce in place of earlier paper-based method of communication. The Act gives legal recognition to digital signature for the authentication of any information or matter requiring legal authentication. It facilitates the electronic filing of documents with government agencies and departments of Government of India. In common parlance, it is known as e-governance. It facilitates the electronic storage of data. It gives legal sanction and also facilitate the electronic transfer of funds between banks and financial institutions. If we look at detail, there are so many features of IT Act 2000. Let us see the main features. The first feature, it is also shown in the table, all these things. All electronics contract made through secure electronic channels are legally valid. Legal recognition of digital signatures are there. There are security measures for electronic records and also digital signatures are in place. There is a procedure for appointment of adjudicating officer for holding inquiries under the Act, which is finalized. There is a provision for establishing a cyber regulatory appellate tribunal under the Act. It is mentioned on the screen, the whole structure. Further, this tribunal will handle all appeals made against the order of the controller or the adjudicating officer. An appeal against the order of the Cyber Appellate Tribunal is possible only in the High Court. Digital signatures will use an asymmetric crypto system and also a hash function which is updated time to time to ensure maximum security. There is a provision for appointment of CCA, that means Controller of Certifying Authority, license and regulate the working of certifying authority. The controller to act as a repository for all digital signatures of the India. The Act applies to offences or contraventions even committed outside India. A senior police officer and other officers can enter any public place and search and arrest without any warrant. That means cognizable feature is there. Now, provision for the constitution of a cyber regulatory advisory committee to advise the central government and controller is also there in the Act. Now, let us discuss the practical aspect. How the Act is applicable? What is the applicability criteria? According to section 1 subsection 2, the Act extends to the entire country. The Act uses article 253 of the Constitution. Further, it does not take citizenship into account and provide extraterritorial jurisdiction. This section, along with section 75, specifies that the Act is applicable to any offence or contraventions committed outside India as well. If the conduct of person constituting the offence involve a computer or a computerized system or network located in India, then irrespective of his or her nationality, the person is punishable under the act. Now, lack of international cooperation is the only limitation of this provision. We need international cooperation for the crimes committed outside India, and the limitation we are facing, we need the cooperation from other countries to establish it. Now, let us see how IT Act is structured. The Act is totally has 13 chapters and 90 sections. Section 91 to 94 deals with the amendment to the 4 Act, namely Indian Penal Code 1860, the Indian Evidence Act 1872, the Bankers Book Evidence Act 1891 and the RBI Act. The Act has chapters that deal with authentication of electronic records, electronic signatures, elaborate procedure for certifying authorities and electronic signature have been spelled out. The civil offences of the data theft and the process of adjudication and appellate procedure have been described. Then the Act goes on to describe some of the well-known cybercrime and lays down the punishment thereafter. Then the concept of due diligence and role of intermediaries in some miscellaneous provision have been described. Now, the most interesting part of today's discussion is what is cybercrime. Now, let us put it simple, offences or crime has been dealt with elaborately listing various acts and the punishment for each under the IPC 1860 and related legislation. Hence, the concept of cybercrime is just a combination of crime and computer. That means, we have to take a broad outlook. A new kind of crime can be committed with the help of computer which might not be listed explicitly in the Act. So, we have taken the main crime which is explicitly given in the Act. Now, cybercrime in a narrow sense and a broad sense is described. Let us see one by one. Any illegal behavior directed by means of electronic operations that target the security of computer system and the data processed by them. This is cybercrime in a narrow sense. Now, cybercrime in a broad sense means computer related crime, any illegal behavior committed by means of or any relation to a computer system or network, including such crime as illegal possession and offering or distributing information by means of computer system or a big network. Now, let us go through the practicalities with examples. Let us start with section 43, the primary section. What section 43 says? Where a person without the permission of owner or any other person in charge damages the computer or computer system or a network, that he shall be liable for penalty and compensation to such person so affected. And the related case is Mphasis BPO fraud in 2005. And how it happened, let us see practically. The time chart has been given on the board itself. In December 2004, 4 call centers employee working at the outsourcing facility operated by Mphasis in India obtained PIN code for 4 customers of Mphasis client Citigroup. They were working for Citibank basically, and these employees were not authorized to obtain the PINs. In association with others, the call center employees opened new account at Indian Bank using false identities. Within 2 months, they used PINs and account information during their employment at Mphasis to transfer money from the bank account of Citigroup customer to the new account at Indian Bank by April 2005. The Indian police had tipped off the scam by a US bank and quickly identified the individuals involved in the scam. Arrests were made when those individuals attempted to withdraw cash from falsified account. $4,26,000 was stolen. The amount recovered was only $2,30,000. Court has decided that the section 43A was applicable here due to the nature of unauthorized access involved to commit transaction. Now, there is section 44. Section 44 says where a person fails to furnish any document, return, report to the controller or certifying authority, then he shall be liable to pay penalty up to rupees 1,50,000 per failure. Further, where a person fails to furnish any information, books or other document within time specified, then he or she shall be liable to pay penalty up to rupees 5,000 per day. Further, provided that where a person fails to maintain books of account or other records, then shall be liable to pay penalty up to rupees 10,000 per day. Now, there is section 65, crimes under section 65. 65 has as tampering with computer source documents. Under this, any computer tampers, conceal, destroy or alter any computer source document intentionally, then he or she shall be liable to pay penalty up to rupees 2 lakh or imprisonment up to 3 years or both. There is a very famous case of Tata Indicom employee who was arrested for manipulation of electronic 32-bit number ESN programmed into cell phones theft were exclusively franchised to Reliance Infocom. The court held that tampering with source code invokes section 65 of the Information Technology Act. There is a crime under section 66 which heads as computer related offences. It is a broad category, so I have written it as computer related offences. Now, under this category of crime, the person shall be liable to pay penalty up to rupees 5 lakh or imprisonment up to 3 years or both. Now, related case is Kumar versus Whiteley Company. In this case, the accused gained unauthorized access to the joint academic network JNet and deleted edit file and changed the password to deny access to the authorized user. Investigation has revealed that Kumars was logging onto the BSNL broadband network connection as if he was the authorized user and made alteration in the computer database pertaining to broadband internet used account of the subscriber. The CBI has registered a cybercrime case against Kumar and carried out investigation on the basis of a complaint by the Press Information Bureau Chennai, which detected the unauthorized use of broadband internet. The complaint also stated that the subscriber had incurred a loss of rupees 38,248 due to Kumar's wrongful act. He used to hack sites from Bangalore, Chennai and other cities too, they said. Now, verdict of the court was the additional Chief Metropolitan Magistrate Chennai sentenced NG Arun Kumar, the techie from Bangalore, to undergo a rigorous imprisonment for 1 year with a fine of rupees 5,000 under section 420 of IPC as well as section 66 of IT Act 2000. Now, there are so many sections and penalties. I have tabulated all these things for a bird's eye view so that you can easily remember and refer the same. Now, there is a section subsection section 66B. Section 66B crime says that any person dishonestly or fraudulently receive or retain any stolen computer resource or communication device, then he shall be liable to pay penalty up to rupees 1 lakh or imprisonment up to 3 years or both. Section 66C further says that any person make use of electronic signature, password or any other unique identification dishonestly feature of any other person, then he shall be liable to pay penalty up to rupees 1 lakh or imprisonment up to 3 years or both. Now, this is a classical case of punishment for identity theft section, and there is a very interesting example. The CEO of an identity theft protection company, LifeLock Todd Davish social security number was exposed by Matt Lauer on NBC's Today Show. Davis' identity was used to obtain $500 cash advance loan. In another international case, Lee Ming, a graduate student of West Chester University of Pennsylvania, faked his own death complete with a forged obituary in his local paper. 9 months later, Lee attempted to obtain a new driver's license with the intention of applying for new credit card eventually. Now, both the cases, it was decided as cybercrime and they were punished accordingly. Further, section 66D crime states that any person dishonestly or fraudulently by means of any communication device or computer resource cheats by personating them shall be liable to the penalty up to rupees 1 lakh or imprisonment up to 3 years or both. Punishment for cheating by impersonation is the title in this category, and there is a very interesting case, Sandeep Varghese versus State of Kerala. In this, a complaint filed by a representative of a company which was engaged in the business of trading and distribution of petrochemicals in India and overseas. A crime was registered against 9 persons alleging offences under section 65, 66, 66A, C and D of the Information Technology Act, along with section 419 and 420 of IPC. The company has a website in the name and style www.jaypolychem.com. But another website jaypolychem.org was set up on the internet by the first accused Sandeep Varghese @Sam, who was dismissed from the company in conspiracy with other accused, including Preeti and Charanjit Singh, who was the sister and brother-in-law of Sam. Defamatory and malicious matters about the company and its director were made available in the website. The accused sister and brother-in-law were based in Cochin, and they had been acting in collaboration with known and unknown person who have collectively cheated the company and committed act of forgery and impersonation. Now, two of the accused, Amardeep Singh and Rahul, had visited Delhi and Cochin. The first accused had others sent emails from fake email account of many of the customer, suppliers, bank, etc. to tarnish the image of the company and its director. The defamation campaign run by the said person named above has caused immense damage to the name and reputation of the company. The company suffered huge loss of several crores of rupees from producers, suppliers and customers and were unable to do the business. This is the loss it has suffered, and they were also punished accordingly. And section 66E again says that any person intentionally capture, publish or transmit image of a private area of any person without consent, then he shall be liable to pay penalty up to rupees 2 lakh or imprisonment up to 3 years or both. There is a section 66E that deals with punishment for violation of privacy. There is a relevant case. A leading university MMS scandal happened under this, and in this university's severe shock to the prestigious and renowned institute happened, and in the university a pornographic MMS clip was apparently made in the campus and transmitted outside the university. Some media reports claim that the two accused students initially tried to extort money from the girl in the video, but when they failed, the culprit put the video on the mobile phone, on the internet, and even sold it as a CD and in the market. The culprit were identified and they were behind the bars, and they were also charged the heavy fine. Section 66F states that any person does any act electronically or with the use of computer with intent to threaten unity, integrity, security or sovereignty of India, then he shall be punishable with imprisonment for life. This is a special case of cyber terrorism which is added with a serious note. Now, section 67. Section 67, there is a punishment for publishing or transmitting obscene material in the electronic form. The offender shall be liable to pay penalty up to rupees 5 lakh or imprisonment up to 3 years or both, and in event of second or subsequent conviction, the person shall be liable to pay penalty up to rupees 10 lakh or imprisonment up to 5 years or both. There is a case law. The case is about posting obscene, defamatory and annoying messages about a divorced woman in the Yahoo message group. Emails were forwarded to the victim for information by the accused to a false email account opened by him in the name of the victim. These posting resulted in annoying phone calls to the lady. Based on the lady's complaint, the police nabbed the accused. Investigation revealed that he was a known family friend of the victim and was interested in marrying her. She was married to another person, but the marriage ended in divorce and the accused started contacting her once again. On her reluctance to marry him, he started harassing her through internet. The accused was found guilty of the offence under the section 469 and 509 of IPC and 67 of IT Act 2000. Now, section 67B, which says punishment for publishing and transmitting of material depicting children in sexually explicit act, etc. in electronic form. The relevant case is, there is an international case, and the Union of India, it happened in 2010 and PIL was launched. The petition sought a blanket ban on pornographic websites. The NGO had argued that website is displaying sexually explicit content held an adverse influence leading youth on delinquent path, and they were punished accordingly. Section 69 says about power to issue direction for interception or monitoring or decrypting of any information through any computer resources. The relevant case happened in August 2007 about Lakshman Kailash K, a techie from Bangalore who was arrested on the suspicion of having posted insulting image of Chhatrapati Shivaji, a major historical figure in the state of Maharashtra, on the social networking site Orkut. The police identified him based on IP address details obtained from Google, and Airtel, Lakshman's ISP internet service provider. He was brought to Pune and detained for 50 days before it was discovered that the IP address provided by Airtel was erroneous. The mistake was evidently done due to the fact that while requesting information from Airtel, the police had not properly specified that the suspect had posted the content at 1:15 p.m. The verdict, the judgment of the case was taking cognizance of his plight from the newspaper account. The State Human Rights Commission subsequently ordered the company to pay rupees 2 lakh to Lakshman as damages. The incident highlights how minor privacy violation by internet service provider and intermediaries could have impact that gravely undermine other basic human right. The person was innocent, but mistake of internet service provider made him culprit, and we should be very careful what we browse on internet. Section 70 state that appropriate government may by notification in the official gazette declare any computer resource which directly or indirectly affects the facility of critical information infrastructure to be a protected system. Any person who fails to comply with the notification, then he shall be liable to the imprisonment of 10 years along with the fine, and the amount of fine is not specified, it is on the discretion of the judge. It may be higher or may be a moderate amount. Now, section 71, which state that whoever makes any misrepresentation to or suppresses any material fact from the controller of the certifying authority, that is CCA, for obtaining any license or electronic signature certificate as the case may be, shall be liable to pay penalty up to rupees 1 lakh or imprisonment up to 2 years or both. Section 72 crime says that if any person who has secured access to any electronic record, books, register, correspondence, information, document or other material without the consent of the person and discloses such electronic record, book, register, correspondence, document or other material to the third person, then the person shall be liable to pay penalty up to rupees 1 lakh or imprisonment up to 2 years or both. Further, crime under section 72A state that if any person who has secured access to any material containing personal information about another person with the intent to cause or knowing that he is likely to cause wrongful loss or wrongfully gain, discloses without the consent of the person concerned or in the breach of a lawful contract, then the person shall be liable to pay penalty up to rupees 5 lakh or 3 years imprisonment or both. Section 73 category crime says that if any person publishes a electronic signature certificate or make it available to any other person without knowledge that certifying authority has not issued or subscriber has not accepted it or certificate has been revoked or suspended, after all three flaws, the person shall be liable to pay penalty up to rupees 1 lakh or imprisonment up to 2 years or both. The crime under section 74 says that if any person knowingly create, publishes or otherwise makes available electronic signature certificate for any fraudulent or unlawful purpose, then the person shall be liable to pay penalty of rupees 1 lakh or person is liable for imprisonment for 2 years or both. There is a crime under section 75 which state that if any person have committed an offence or contravened any provision outside the India and if the act or conduct constitution the offence or contravention involves a computer system or computer network located in India, then the provision of this act shall apply also to any offence or contravention committed outside India by any person irrespective of his nationality. This is a very important crime because maximum criminal target physically located outside India, then they are also liable, and this is a very provision has a deep impact. Now, section 76 state that any computer system, floppies, compact disc, tape drivers or any other accessories related thereto in respect of which any provision of this act, rules, orders or regulations made thereunder has been or being contravened shall be liable to confiscation by the authorities. However, if it is proved that such resources were not used in committing fraud, then only person in default will be arrested. We have started all cyber crimes which are mentioned under IT Act 2000. Now, as the title of this session also talks about IT Act 2008. Now, first of all, first question arises in the mind, why did the need of IT Amendment Act 2008 was arised? The IT Act 2000 being the first legislation on technology, computer, e-commerce and e-communication was subjected to extensive debate, elaborate reviews, with one arm of the industry criticizing some section of the act to be draconian and other stating it too dilute and lenient. There were some obvious omission too, resulting in the investigators relying more and more on time tested Indian Penal Code, even in technology based cases, with the IT Act also being referred in the process, with the reliance more on IPC rather than IT Act 2000. The Information Technology Amendment Act 2008 as an act to amend IT Act 2000 received the President's permission on 5th February 2009. Several legal and security experts are analyzing the content and possible impact of the amendments. The objective of this note is to try and study the possible implication and impacts on Indian companies. This note is not an comprehensive analysis of the amendments. However, it covers specific vital points that could impact Indian IT companies. The main improvements are discussed. The first improvement or addition under amendment in 2008 Act is data protection. The IT Act 2000 did not have any specific reference to data protection. The closet being a provision to treat data vandalism as an offence. The government introduced separate bill called Personal Data Protection Act 2006, which is pending in the parliament and is likely to lapse. The IT Amendment Act 2008 has introduced two sections that addresses data protection aspect. The sections under consideration are section 43A, that is compensation for failure to protect data, and section 72A, that is punishment for disclosure of information in breach of lawful contract. Description of section 43A, where a body corporate possessing, dealing or handling any sensitive personal data or information in a computer resource which it owns, control or operates, is negligent in implementing and maintaining reasonable security and practice and procedure, and thereby causing wrongful loss or wrongful gain to any third person. Such body corporate shall be liable to pay damages by way of compensation to the person so affected. This is newly section 43A under Amendment Act 2008. Now, second part is section 72A. Under this section, disclosure without consent exposes a person, including an intermediary, to 3 years imprisonment or a fine up to rupees 5 lakh or both. In this, even intermediary is accountable. So, this is very interesting and it has a great significance. Now, this section uses the term personal information and not sensitive personal information as given in section 43A. Hence, it could apply to any information obtained to deliver service and therefore broadens the definition of information, and it justifies our MOOC's module title Information Security. So, you must pay special attention to section 72A. Now, information security across the amendment, there are several references to service provider or intermediaries, which in some form would apply to all Indian companies. Now, there is an example of section 67C, that is preservation and retention of information by intermediaries. Intermediaries shall preserve and retain such information as may be specified for such duration and in such a manner and format as the central government may prescribe. Any intermediary who intentionally or knowingly contravenes the provision shall be punished with an imprisonment for a term which may extend to 3 years and shall also be liable to fine. The notification on time for preservation etc. are not yet released. However, since this is a cognizable offence, any police inspector can start investigation against the CEO of a company. Apart from the two aspects discussed in this presentation, there are two other areas which could also be considered. Section 69, that gives power to issue direction for interception, monitoring or decrypting for any information through any computer resource. Further, section 69B, which talks about power to authorize to monitor and collect traffic data or information through any computer resource by cyber security. There is a insertion of cyber risk management and response that must be revisited by every enterprise to secure critical asset and meet compliance need. The IT Amendment Act 2008 provides a few additional factors that can have a significant impact on business. IT regulation and laws are sure to get more stringent and refined, making organization more prepared to take on today's threat. Now, with this, I have covered the highlights of major amendments done via section 2008 amendment bill. Now, there is always a discussion, very interesting discussion on 66A which no longer exists, and lot of students, you students are browsing social networking site all the time. You must know what section 66A was all about. A special discussion I am putting forth for you. The section which deals with sending offensive messages through electronic means reads, any person who sends by means of a computer resource or a communication device any information that is grossly offensive or has menacing character, or any information which he knows to be false, but for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred, or ill will persistently by making use of such computer resource or a communication device, any electronic mail or electronic mail message for the purpose of causing annoyance or inconvenience, or to deceive or mislead the addressee or recipient about the origin of such message, shall be punishable with imprisonment for a term which may extend to 3 years and a fine also, which is not mentioned. Now, there was a live case. A very famous cartoonist Asim Trivedi was arrested for displaying cartoons that mocked Indian Parliament, which is not accepted at all. What happened? Cartoonist Asim Trivedi was charged by Cybercrime Cell of Mumbai Police with sedition under section 124A of the IPC and prevention of insult to National Honour Act, and section 66A of IT Act on 9 September 2012 for displaying cartoon that mocks Parliament and corruption on his website and Facebook pages as well. The Trivedi's cartoons purposely depicted Parliament as a giant false structure and showed the national emblem in a very wrong manner. So, there was a case registered against him. The second case was about Jadavpur University professor, and who was arrested by West Bengal police for sharing cartoons on the leading politician of the state. In the April 2012, the West Bengal government used section 66A against the professor of Jadavpur University for circulating emails that mocked the chief minister of the state. The professor and his neighbors were arrested for circulating a cartoon of that leading chief minister, and based on a scene from Satyajit Ray's popular children detective movie Sonar Khela. And because of all these complaints, what happened in 24th March 2015, the Honorable Supreme Court delivered judgment striking down section 66A of the Information Act 2000, and it was in response to a PIL launched by a student of law and challenging the constitutionality of this provision. The court held that the provision of 66A of IT Act is derogative to the article 19 subsection 1 subsection A, and as such it is an arbitrary provision which breaches the right of citizen to have freedom of speech and expression of their views on internet. As such, the provision concerned is constitutionally invalid, and as such struck down its entirety. Now, my dear students, today we have discussed the very significant IT Act 2000-2008, and under this course Information Security and Cyber Forensics. All the powers and legal guidelines of cyber forensics and information security is taken from this act which I have discussed today. And if I see the structure today, we have discussed the meaning of IT Act, why IT Act is important, what are the features of IT Act, what are the major crimes, what are the major amendments, and a special discussion on Act repealed and why it was repealed, to give you a logic how law operates, especially in the IT Act. So, I also advise you to browse the website www.meit.gov.in, the official website of Ministry of Electronics and Information Technology, for daily upgrades. Personally, I expect and avoid you to follow the IT rules and safety precautions in cyber world, especially while you browse social networking websites like Facebook, Twitter or Instagram, because the maximum victim, even the person who are criminal, belongs to your age group. So, I want you to be extra precautious, and thank you all the students, and I wish you all a very happy learning. Thank you so much.